Welcome back, class. Today is when we will begin to explore the topic of contracts. I'm going to have to cover a lot of material fairly quickly, and so I'm going to be actually speaking from the PowerPoints that I've posted in the module labeled contracts, which you guys should access as soon as you can, so that you can follow along with each of these lectures. I'm going to be moving fairly quickly through this material, and it's going to be a lot of material that we're going to cover. But we can't leave business law without having some understanding of contracts, what a contract is, what it's for, and to appreciate its centrality to business law. The contract is, in fact, the thing that makes trade possible, right? Because it protects the obligations that are due to a party, as well as the obligations, mutually, right? It's a way to enforce promises. And essentially, a contract is a mutual promise. And we'll understand why this mutuality is important shortly. But the definition of a contract is a legally binding agreement. And in the following sections, we're going to explore several different aspects of what that means and what makes it so. All right, and so all sensible people are selfish, and nature is tugging at every contract to make the terms of it fair. All right, that's poet Ralph Waldo Emerson, not a legal scholar, but simply an observation. All people enter into contracts. Every transaction into which you enter is a contract of sorts. What you typically think of as a contract that you sign or that you click on, in the case of the internet age, it'll be a good way to explore what it is that makes these things contracts. What is it that makes them legally enforceable? But other things, much more simple transactions may also be contracts. So they don't have to be written. So in this section, we are going to address 5 questions. Right. First, what is a contract and its objective theory? Right? That's a compound question. So what is a contract and what is the objective theory of contracts? Right. Secondly, the 4 basic elements, I kind of break it into 5, but I'll explain that. But the 4 basic elements necessary for the formation of a valid contract. Third, the difference between an express and an implied contract, among other different categories. This is nature and classification. So we're going to be dealing in a number of ways of classifying contracts. So I guess the third question would be, how are contracts best classified and understood? Fourth, how does a void contract differ from a voidable contract? Or alternatively stated, or an unenforceable contract. Alternatively stated, what are these defenses to enforcement, I guess you'd say, and how do they apply? And fifth, what rules guide the courts in interpreting contracts? So our base definition of a contract is a legally binding agreement, right? Composed of offer, acceptance, consideration, capacity. Offer, acceptance, consideration, capacity, legality. And I broke it into 5. I was supposed to say it in 4, so let me restate it. A contract is a legally binding agreement composed of agreement, consideration, capacity, and legality, right? I break agreement into offer and acceptance, but that's my personal preference. Offer, agreement, consideration, capacity, legality. Agreement, consideration, capacity, and legality form a legally binding agreement called a contract. All right, that was a little bit awkward the way I stated that, but we're going to try to get through this with as few re-records as possible. So we're just going to move on. So as an example, I would take case 10.1, which is Panhandle Realty LLC versus Ollins, right? And in this case, Panhandle Realty built luxury homes on spec, meaning without having a predetermined buyer. And this particular property was built in Westport, Connecticut, and Mr. Ollins basically signed a lease for the property because he wanted to rent it. And he sent this on January 17th. The party met and then they negotiated changes to this lease agreement. And a lease is simply an agreement to rent property, right, between two parties. And so Ollins gave Panhandle a check for the amount of the annual rent, which was $138,000, and said that he planned to move into the home on January 28th. It's about 11 days after the original meeting. Before that date, Panhandle removed all of the staging from the property, including like furnishings that it used to show the property. His bank, Ollins's bank, basically stopped payment on the check when Panhandle found out. They contacted Mr. Ollins and he said he was unable to pursue any further interest in the property, right? The company Panhandle was unable to find a tenant, and so they sought a judgment against Ollins. And in Panhandle's favor, the trial court found that he had breached the lease. They awarded the damages of $138,000, the full amount of the annual rent, $8,000 in utilities fees, interest, and attorney's fees. So Ollins is appealing this judgment, saying that this lease was not enforceable. He hadn't even moved in, right? But the court says in order for a contract to exist, there must be a meeting of the parties' minds. If there had been a misunderstanding between the parties or a misapprehension by one or by both so that their minds had never met, no contract has been entered into, and the court will not make for them a contract, which they themselves did not make, right? So the court here is saying essentially that in order for there to be an agreement, there must be a meeting of the minds, right? And so then they go on to look at what evidence is going to show whether there was a meeting of the minds or not. So the parties there was evidence to show that the parties entered into a valid lease agreement because there was a true meeting of the parties' minds to the essential terms of this agreement, which was negotiated, right? Panhandle had provided the defendant with a draft lease. The defendant, stated that he and the plaintiff's representatives made revisions. That's negotiation, right? And then he tendered a check, a signed check, post-dated to the start of the lease period, and he noted that it was for the 1-year lease, right? And he signed the lease, right? No evidence in the record to support defendant's contention that he didn't intend to be bound by the lease when he signed it. So that is not asking notice about Mr. Ollins' feelings or his perceptions, but what they're looking at is cold, hard facts. I'll explain why that's important. As in any other contract, the measure of, the defendant's apparent unilateral change of heart by disregarding the lease agreement does not negate the parties' prior meeting of the minds that occurred at the time that the lease was executed. There's ample evidence in the record evincing the intent of the parties to be bound by the lease when they signed it, and thus to support the court's finding that the lease agreement was a valid and binding contract which the defendant had breached. So essentially, they're saying that because you can't show facts and circumstances that illustrate Mr. Ollins was not intending to be bound by that lease, and it's a simple case, it's very straightforward, then he can't then challenge it, simply because he says he can't pursue an interest in the property. Right. So that that holding of Mr. Ollins to this standard, this is called the objective theory of contracts. Right. And so this is where we're trying to determine the intent of the parties. Right. And it simply states this objective theory of contracts. It is the intent of the parties is judged by concrete manifestations, things that you can point to, right? That have been that the party intended to or did not intend to, right? Be bound by the facts. For example, if Mr. Ollins had put in a statement, a signed statement that says, I retain the right to change my mind or to withdraw my lease agreement within 3 days or some number, right? And then said I have no further ability to pursue an interest in this property, then, right, that would have been an objective manifestation that he didn't intend to be bound for another 3 days. Right. Objective theory of contracts requires that you have something concrete to in order to establish the intent, if that is indeed the intent to form a contract, if that is the issue, right? And so these facts could include what the parties said, right? What the parties did, how they acted, how they appeared, the circumstances surrounding the transaction. There are limitations to this that we'll get to because you can't refute what's actually in the written agreement or in other signed writings, right? With just mere behavior, but we'll get back to that. First, we're going to take a step back and look at what is it that happened when Ollins and Panhandle Realty met, all right? And that's the formation of an agreement. We'll do that right next after you respond to the prompt. Thank you, guys.